We are back on the record in docket number 17-10001. My name is Joe Reynolds, and I'm presiding over this matter in the investigatory workshop for the Energy Choice Initiative. I am here in Carson City, and we also have participants down in Las Vegas. We spent this morning discussing some broader policies, goals, and interpretations of this proposed constitutional amendment. This morning, one observation I just want to put on the record, and again, it's not a criticism, but just an observation, is that our First Amendment to the United States Constitution is 45 words, and it's been litigated for the past 200 years over and over again, and we're still, as a nation, struggle with the scope of its meaning. This constitutional amendment is around 450 words. And so at some point, every comma, period, in word chosen will be reviewed and looked at, I think, closely. And so these conversations, I think, will happen for quite a long time into the future, as it does with all constitutional provisions. Before we left for the break, I mentioned that I wanted to turn over the mic a little bit to anyone who's here in attendance first in Carson City, if they would like to give comments, broader comments, with respect to the issue that we're discussing today in today's workshop regarding amendments or repeals to any current laws or policies or existing energy programs that may be necessary to establish an open and competitive electric market pursuant to this ballot question. And so with that, and also any issues that you think that I should go into in further detail, either later in today or next week in a follow-up, I'd be open to hear any of those suggestions. So with that, is there anyone in Carson City that would like to come and speak at the microphone at this time?
For the record, Fred Volz. One of the new laws necessary to implement the constitutional change in how Nevadans receive retail electric service flows from the answer to one of the proponents' frequently asked questions on their website. And that website asks, what happens if my new energy supplier goes out of business? The answer that they give is the state of Nevada will appoint a default energy provider. This expectation begs the question whether that possible appointment will happen by the Governor's Office of Energy, the Public Utilities Commission, a call center, or some other entity. It also raises the question of how and by whom a similar assignment will occur for those who make no selection, since 90% of Nevadans will be forced into new retail electric provider status per the initiative. Looking at some of the existing state statutes and how they might need to be changed, the first one that comes to mind is NRS 702.150(1) and 2. They presently preclude co-ops, municipals, and general improvement district electric customers from receiving assistance with their bills from the State Welfare and Supportive Services Department and the State Housing Division. Reworking this provision to treat all Nevadans who struggle to pay their electric bills equally needs to be considered in the scheme of an open marketplace. NRS 702.160 describes the assessment of the universal energy charge, but does not indicate if the prospective community collaborative associations, also known as community solar, will pay this charge or be exempt from this charge. NRS 704.069, 1A and 1B call for general rate cases. Will all new electric providers in the state file general rate cases, or will the marketplace dictate what rates the providers will charge to retail customers? Similarly, NRS 704.100 lays out extensive provisions for filing changes in rates and revenues. Will these requirements disappear with an open marketplace for retail electric service? And if there are no more general rate cases for electric providers, then NRS 704.110, 3A and 3B, 6, 7A, and 10 all need modification or outright deletion. NRS 704.120 and 704.130 insert the PUC in the court system into what the initiative claims is a choice and open marketplace for selection among retail electric providers. Price and service are to impact which retail electric providers survive and thrive in a marketplace. Those providers who fail to deliver on either metric will lose customers and ultimately fail to exist as a Nevada business if they don't improve sufficiently to attract customers or they are not providers of last resort. The oversight powers given the PUC and the courts on what private companies choose to charge in a competitive marketplace in both NRS sections likely need deletion or substantial modifications to reflect that marketplace reality. The situation is similar to the price of prescription drugs, another necessary commodity for those fighting disease. No government entity establishes a fixed price. Rather, insurance companies determine how much they will reimburse their policyholders for said drugs, or those without insurance pay the out-of-pocket price established by retail distributors. NRS 704.183, Section 1 calls for examination of electric utilities by the PUC, but in a genuinely open marketplace, the marketplace, that is the customers, will decide which retail electric providers survive or fail. NRS 704.187 calls for various measures of deferred accounting. The legacy asset expenditures of NV Energy, which are not retained for the transmission and distribution functions, will be recaptured through a surcharge on future bills of former NVE customers. New entrants to Nevada will have little to no infrastructure requiring long-term payback. This provision becomes largely irrelevant if the initiative passes. NRS 704.210, subsection 1A, 1B, and 1D indicate there are current requirements to create rate service classifications and joint rates between utilities. In a marketplace, it is up to the entities to make these choices and provide adequate service at a competitive price to retain customers. NRS 704.225 interrupts the marketplace and free flow of competitive pricing by giving irrigation customers preferential rates. The rates charged need to be reflective of what competitors will provide. NRS 704.310 also impedes the marketplace from freely exchanging electricity between non-utility generators. NRS 704.329 posits a monopoly scenario for mergers, acquisitions, and changes in control of electric utilities. With the initiative's new marketplace of providers, why is the PUC needed to supervise how private companies choose to conduct their businesses if retail electric customers can choose to go elsewhere for their electricity? The certificates of public convenience and necessity also become irrelevant in a competitive retail electric environment and call for reworking or elimination of NRS 704.330, subsections 1, 3, 4, and 6, and NRS 704.410 concerning transferring certificates of public convenience and necessity. NRS 704.390 involves ceasing and desisting electric service through the PUC, which becomes a moot issue in a competitive marketplace where providers are free to come and go as they see fit. At least regarding electric service, the requirement, either here or in the Consumer Bill of Rights, should be stated that retail electric providers choosing to terminate service with their Nevada customer base provide at least 180 days notice to impacted customers so they have sufficient time to shop for and secure another provider. NRS 704.400, 704.635, 704.640, Section 1, dealing with certificates of public convenience and changing services, has little impact in an open marketplace, since the PUC will no longer be in the business of granting or overseeing monopolies. NRS 704.677 deals with certificates of public convenience for cooperatives and nonprofits. Under the initiative, there is no need for these certificates, and this provision should be stricken. NRS 704.766 through 704.775 focus on the net metering situation and present a disturbing absence of guidance and direction on the following operating problems to come, should the initiative pass. While the reimbursement rates to customer generators have been reimposed by legal decree multiple times when dealing with a regulated monopoly, what happens to those same contracts regarding customer-owned generating systems and the purchase of excess power by the legacy electric provider? The legacy electric company would no longer be a buyer when it operates solely as a distribution and transmission company, which is yet another difference with other states that have gone down the choice path. Another question, will legislation be passed requiring the legacy electric company to purchase the excess energy from the customer generator and force the legacy company to remain in the retail business? Will renewable energy be sourced outside of Nevada by the new companies, and will there be any restriction on that? Can the contracts be unilaterally assigned by the legacy electric company to another new retail electric provider per the provisions of the contract, which assumes another retail electric provider needs, wants, or otherwise finds those contracts economically viable and desirable, and at what reimbursement level? Will the existing contracts be abrogated altogether by the legislature and new ones required to be drawn with new retail electric service providers as a condition precedent of their ability to do business in Nevada? How will the customer generators with leased generation systems be treated, and what happens to their long-term leases? That is there a market for their product? Who will do the legal review of each of the 25,000 plus contracts to determine what can and can't be done? What happens to new customer generators who begin operating their systems between now and before November 2018? What happens to customer generators if the initiative passes and there are no takers for their excess electric product? Which retail electric service providers will be required to accept and pay for excess energy produced by customer generators? Will providers of last resort and mandated buyers of renewable energy need to isolate costs of both and charge those who are directly impacted rather than assessing all ratepayers of a retail electric provider for these costs? Ultimately, the future arrangement customer generators have regarding the sale of their excess electric production regresses into another black hole of uncertainty absent new legal constraints that contradict a competitive marketplace of electric providers who freely engage in negotiations about terms of service with retail electric service consumers. And finally, NRS 709 presents a different set of issues addressing franchises for electric utilities, starting with 709.010 and continuing into 709.040, Section 1, 709.050, Section 1, 709.060, 709.070, 709.080, 709.090, 709.100, 709.110, 709.180, to 709.230, 709.250, 709.260, and 709.270. As there will no longer be any franchises, all of these provisions regarding electric services need to be stricken. NRS 709.110 and 709.230 present another challenge as they provide for 2% of the net profits from the stricken franchises going to county schools. And the question becomes, will those lost funds be made up some other way if another retail electric provider competitively takes some or all of the franchisee's business away? And finally, new statutes and regulations will be needed to establish the providers of last resort. And I have mentioned in previous comments about the problems with the people who are on a master meter situation, both in apartments as well as mobile home parks. Thank you.
Thank you, Mr. Voltson. I let you go longer than 3 minutes, but I thought the points you were making were well thought out and important to be in the record. Are there any other commenters? I see Mr. Dylan Sullivan.
Chairman, thank you. For the record, this is Dylan Sullivan from the Natural Resources Defense Council. I don't want to presuppose what your list of questions is, and I also don't want to regurgitate the comments that we filed. But I do want to spend some time on renewable energy, if that's okay.
Yes, please.
So one of the things that we identified in our comments and reply comments in this proceeding is, I guess I could summarize it as, we shouldn't expect renewable energy to just happen as a result of deregulating generation service or moving toward retail competition. And in fact, and I say this not just from looking at incentives from afar and sort of supposing what might happen. I think there's good evidence from other states' experience in moving toward retail competition that move creates some issues that just have to be addressed by policymakers if it is still going to be an interest of the state to put more renewable energy in the ground for reasons of air quality, reducing water use, providing more resource diversity, economic development, all those litany of reasons that I think it makes sense for the state to do this. And what I focus on in our comments is there are a couple of incentives in the electricity retailing business that are just sort of natural incentives, and they produce good outcomes in some contexts, but difficult outcomes in this context. And one of those incentives is just customer migration. You know, customers can switch among providers. It doesn't really make sense to limit customers' ability to switch providers, you know, extensively. But that means that providers don't always have confidence in the amount of load that they're going to be serving in the future. And this is actually the reason for why reliability and ensuring reliability is such a focus in places where states move toward retail competition. You know, in California, there is a state-directed resource adequacy process that ensures that, or that tries to ensure that, you know, utilities who are operating in the wholesale energy market still make long-term investments in order to make sure that we have enough steel in the ground to keep the lights on, of course. Something similar happens on renewable energy, because if providers don't know how much they're going to be serving in the future, it can make it difficult for them to make long-term commitments to renewable energy. And the example that I point to, and that has been spoken about before in front of the Governor's New Energy Industry Task Force, is the example of Illinois, where it's actually a very complicated history, and I worry about oversimplifying it, but basically it's been difficult to get retail providers to make investments in renewable energy projects in the state. And instead they've relied on short-term REC products, and the state hasn't really been able to meet its renewable energy goals. And it's because of this, you know, ability for customers to leave providers, and that creates difficulty in I think driving investment long-term. And then of course the other important incentive is just you know, providers compete on price, and anything that might change price creates a risk. And of course we've talked before, other people in this room, about the big price declines in renewable energy that a lot of states have benefited from, and that we've seen in Nevada, you know, record low prices for solar PPAs. But I think that that's still a concern. And what we propose in our comments is that providers have to make some sort of long-term commitments to meet what we hope will be an expanded RPS. And that you know, providers not be allowed to just use short-term REC products to comply, because we've seen in other states that hasn't led to you know, large developments of renewable energy resources. And I'm not exactly wedded to the recommendations that we made, but I do think it's an important issue. You know, how do we ensure long-term renewable energy developments and steel in the ground, renewable steel in the ground, as we move to this transition, given some incentives of the electricity retailing businesses that sort of lead to a more short-term focus among providers. So maybe we'll have an opportunity to talk more about this later, but I wanted to make sure that I had the opportunity to make that point.
Thank you, Mr. Sullivan. Anyone else in Carson City that would like to give some comments? Yes, Mr. Van Cleve.
Thank you, Mr. Chairman. Brad Van Cleve for Valley Electric Association. I just wanted to follow up a little bit on the issue we were talking about about the application of the initiative to co-ops. And I believe it was Ms. Terwilliger pointed out that in many states, the co-ops have simply been exempted from energy choice type legislation. But as I said earlier, I think that given the language in the initiative about every person, that co-ops should not be exempted. And so what our job here is to figure out how it should apply to them. And under current law, the cooperatives boards have the authority to determine the products and services and the rates in general that will be provided to the members. And the commission regulates the co-ops in two ways. One, there's a requirement for annual reports to be filed. And two, the commission issues certificates of public convenience and necessity, which effectively define the service territories of the co-ops. And we believe that both elements that I described should be preserved. One, the cooperative boards should retain authority over rate making and services, and the commission should retain authority over defining the distribution service territories that the utilities in the state operate within. So we would not agree with the comment that was made just a little bit earlier that those provisions about CPCN should be stricken from the statute. But given this construct, I think a reasonable approach would be to allow the cooperative boards to determine how choice will be offered to their members. And if we take that approach, the legislature doesn't need to define detailed rules about how a co-op will implement choice. So for example, the co-op board could determine whether to phase in by customer class. It could determine what kind of charges would apply to somebody who bought from a third-party provider, including possibly recovery of stranded costs through some kind of transition charges. The co-op board could also determine what kind of provider of last resort service would be provided and what the terms of that would be within the co-op service territory. So in this way, we would give each co-op the ability to sort of tailor how choice is implemented to their unique circumstances. And, you know, rather than have the legislature prescribe that, leave that to the co-op boards. They're clearly going to have to stay within the parameters of the constitutional amendment and offer choice, and if they go outside those parameters, they would be subject to challenge. But I would suggest that neither the legislature nor the commission needs to prescribe in detail how the co-ops might implement the initiative.
So, if I understand correctly, let it be more of an organic process in terms of let the co-ops come back to, say, the legislature or the commission or whoever and say this is what works for us,
Right.
as opposed to being prescriptive and kind of top down.
Right. And it might be different for each co-op. I mean, they would have to determine based on their circumstances, you know, what kind of, for instance, federal power contracts they had, that kind of thing, what the best way for their members to implement it would be.
Well, thank you for those comments. Mr. Ross.
Thank you. Ned Ross with RISA. I just wanted to point out we have working with us a gentleman named Phil O'Connor, who is a former chairman of the Illinois Commission, and he is watching the hearings today and lighting up my phone with text messages as Mr. Sullivan was speaking about Illinois. So I just want to point out he will be happy to share all of his expertise on what's going on in Illinois, but he did say that the renewable program there is not in as dire shape as seemed to have been disclosed. So I just want to point out we'll probably be submitting written comments on the back end. I think you have a early February time period when we can submit comments. So just expect to see more from us at that point on some of the comments you hear.
Great. Thank you, Mr. Ross. Hello, good afternoon.
Good afternoon. Jordan Pinyuv with the California ISO. I just wanted to say a couple of quick words here. I think most of the discussion today has rather been around the language of the statute or the initiative and kind of the retail impacts of that. From our perspective, I think there's also going to need to be legislation on the wholesale market side of the issue. Most likely some sort of broad enabling legislation that hopefully would allow the PUC to actually conduct whatever studies and further further implementation that would be required for the wholesale markets. And to that effect, I'm sure we'll get into the wholesale market issues much more tomorrow. And I just want to give you and everyone in this room a heads up that tomorrow the California ISO will have here in the building both myself and also a couple of other folks. We're going to have our Stacy Crowley, who's the Vice President for Regional and Federal Affairs, and then also Keith Casey, who is the Vice President for Market and Infrastructure Development. So with the three of us in the room tomorrow, we're hoping that we can answer any questions that might come up on the wholesale market side.
No, I appreciate that very much. I see Phil in the audience right now as well. So thank you for being here.
Yeah, no problem. Thank you.
Is there anyone else in Carson City that would like to give any comments before we go further with the workshop? I'll move on down to Las Vegas. I see Miss Angel DeFazio, and Miss DeFazio, I'm just going to say it right off the bat. If you make disparaging, defamatory remarks, this is not the time and place for that. And so if you have anything to add specific with respect to the legal issues that we're looking at, I'll let you have an opportunity. But if you go out of bounds on that, we're going to stop you. So go ahead.
Angel DeFazio, for the record, first of all, I have enough class not to go to that end. Now, everything here regarding legal, you're ignoring one major factor, the ratepayer. How are they going to be impacted? One of my main concerns, and I know with other people, it's the potential for their personal records to go out into a centralized database. And even the BCP, during one of the government committee meetings, expressed a concern regarding NRS Chapter 603A that delineates security of personal information. Now, when NVE takes on a customer, they rely on Equifax, or if the customer pays a deposit, or if they have a letter from another utility. Telecom industries, for example, don't have a database. So why should the energy companies come in and have our personal information to take a pick and choose discriminatory approach? Oh, well, you're using a lot of power and you're a good pay, so we're going to take you. No, they should be under the same constraints as NVE when it comes to choosing a customer. That's number one. Number two, the public really needs to have education, because as some people have stated about the rules regarding low income, disabled, etc. Now, if these new companies coming in don't have these types of policies that we have enacted in our state, what are these people going to do? They should be the priority. When you asked for which number should be what, the customer, we are number one. Everything else is secondary because, as you said, people want choice and they want to know their bills are coming down. But they're also going to want to know, are we losing services? Are we not going to have privacy? This could all impact the ballot initiative come November. You have to protect the ratepayer. Whatever laws and protections and programs that are in effect now should be in effect then, especially NRS 704.1835 and NAC 704.390 regarding the termination of services. How do we know what their criteria is versus ours? Now also during inclement weather, I mean, what are we going to do with the heat, with the turnoff point? Do they have the same temperature range as we do? We don't know. But if they come in, why should we have to put our health at risk because they want 108-degree temperature before they can turn it off, and we've got, what, 105 or so? That's another issue. What about having access to people to talk to regarding their bills? And the credit arrangements, what are they going to do? Are they going to change the credit scores that NVE uses? And, let's see. Also, there was talk about the default and provider of last resort. They're taking more of a risk with low incomes, low pays, etc. In a lot of other industries, they tend to have higher costs, kind of like insurance. If you're a bad driver, you're going to be penalized. The problem is that going to happen to people here? The state promotes conservation, renewable energy. People conserve, and that's the problem. They're going to be unattractive to new companies because they're not generating a lot of power. The customer needs to be your number one priority at all levels. And especially with the provider of last resort, if they're going to have the ability to charge more because of that, there should be a cap, especially on the people who are being thrown in there, not due to anything that they've done. It's just that any company coming in is not going to make enough money off of them. This is what needs to be your major priority before anything else. Thank you.
Thank you, Ms. DeFazio. Is there anyone else in Las Vegas that would like to give any additional comment at this time on this workshop? I'm hearing and seeing no others, either in Las Vegas or here in Carson City. And then so I'll move on with some additional questions that I have that have come into my mind as a result of these comments, and also some prior to. And that is with respect to to NEM, the Net Energy Metering legislation. And when we're looking at what laws need to be amended or repealed pursuant to this ballot initiative. As I think everyone in this room knows, we have Assembly Bill 405, which is very landmark legislation regarding net energy metering here in Nevada. And will passage of this ballot initiative impact that legislation and the decisions that the Commission is making or has made regarding the implementation of that legislation? Does anyone have any thoughts on that? And especially with respect to right now, pursuant to AB 405, we have NV Energy is required to accept excess energy generation fed back to the grid. Now, if NV Energy is no longer in the position to do so, either because we have eliminated the regulatory compact, will there be a market incentive for other companies to step in and take that on the way it's currently envisioned in the AB 405? Mr. Sullivan, thank you.
Chairman, for the record, Dylan Sullivan from the Natural Resources Defense Council. And I'll attempt to try to answer your question, or at least address the topic. And you mentioned Assembly Bill 405. The drafters of Assembly Bill 405 in the legislature tried to, I think, presuppose some of these issues and anticipate them. And in section 28.7 of that law, it basically holds that providers in the new, in a new retail choice environment be required to offer net metering to customers. But I don't know to what degree they specified exactly what that means. You know, it's net metering, but is required to be provided, but sort of on what terms?
Exactly.
Is the question. So I think the people of Nevada and the legislature has pretty clearly stated that, especially people who have already installed net metered systems, that the state has basically made a commitment to those customers that they are going to be able to, keep providing the benefits to the grid that they've been providing and keep getting compensated for those. And I think it's a really interesting question, sort of on what terms providers should have to provide service to those existing net metered customers. And different states have answered this question differently. So I think in a lot of the PJM states that have net metering, the distribution utility or the provider of last resort is the entity that provides net metering, basically on the same terms that we sort of think about it here. And in Texas, providers aren't required to offer net metering. Some of them do as part of their competitive offerings. But to me, what seems most reasonable for existing, for customers who have net meter systems in the date of the market transition, is that providers basically be required to offer non-discriminatory access to net metered customers. So on the same sort of tariff that they provide to other customers, because I think that would sort of keep intact the policy decision that the state seems to have made for those existing net metered customers.
No, I think, and thank you for coming up. And I guess what I'm grappling with is, we can say as a policy, we offer, want new providers to offer net metering,
Yeah.
but it really comes down to what terms and how much people who have rooftop solar systems get paid back for the excess generation. And right now, it's that framework is mandated by law.
Yeah.
Where we say by law you get 95%. Now, when we take away, we have a constitutional provision enacted in place and open that up to competition.
Yeah.
We take away that legal imposition to say by law a provider has to pay a certain amount, because right now we are mandating that NV Energy pay that amount. They don't have a choice.
I don't know that I agree with you there, and I think the reason is the final section of the amendment that we talked about earlier, that basically allows existing public policies on clean energy to continue under the amendment. I think that provides a hook for the legislature to require some things related to net metering of providers or of providers of last resort.
No, in whether agreeing or not, I'm just asking. So
Yeah.
I'm trying to figure that out, and I appreciate you
And
being
I
up
am
here
still,
to.
I'm not as I'm not quite an expert in net metering and in Nevada net metering in particular, and these are just the thoughts that I've developed. And I think it's another question of what sort of net metering or treatment providers should provide to new customers going forward, customers who haven't installed systems on the date of transition.
And really kind of what I'm getting at is the legislature can't exempt a statutory provision from the purview of the Constitution. So even if legislature wants to say anything in the Constitution won't touch this piece of legislation, they can't. Just under Law School 101, the Constitution rules supreme, period. And so any statute cannot exempt himself from that framework. And so that's what kind of where I'm getting at. And I see Mr. Lucas Folletta, and again, I'm just trying to understand.
And I haven't taken Law School 101 because, like I mentioned earlier, I'm not an attorney. But I do think the final section of the amendment is important for this purpose.
Thank you. Thank you. Mr. Folletta, thank you for coming up.
Sure, thank you, Mr. Chairman. Lucas Folletta, for the record, representing the Solar Energy Industries Association. I think, Mr. Chairman, the question you asked is a fair one. I think there's a couple things to keep in mind with respect to this issue. And I think Mr. Sullivan hit on a couple of them. One, I think that it is important to note that the language of the petition itself states specifically that the purpose of the petition is not to, and I'm paraphrasing, but undermine or disrupt any existing renewable energy policies of the state. So clearly, I think the intent, at least with respect to the petition, is to not disrupt, for example, the net metering policy of the state that exists today. So the question, I think, becomes fairly is, how do we conform the existing policy to a competitive dynamic in a way that is true to the intent and the structure of the policy as it exists right now? And I think there may be some different ways to do that. And I think, providers, retail providers in particular, are in the best position to potentially, speak to the variations on that topic. But what I would say is that I do not believe that the language of the petition itself, insofar as it provides a right to meaningful choice, undermines the structure of the existing net metering policy. Let's say, for example, you made it a requirement, or the legislature made it a requirement of every retail provider that they offer net metering on the same terms as it exists today. Those terms being more or less a one-for-one credit until you get to a certain point. Sorry, a one-for-one credit until you get to a certain point, and then you step that credit down in excess of that. For one, I think that customers' right to choice is still being satisfied, even if a provider is required to provide a credit or purchase electricity, depending on how you characterize what's going on, at a specified rate. And I think that what the Constitution will require is that retail customers have a right to choice. I also think that it's possible that retail providers may be in a position to offer meaningful choice as it relates to net metering, or meaningful choices, even if that rate for the electricity generated by the customer and sent back to those providers is established by law. In a competitive environment, there will presumably be other ways that retail providers can distinguish themselves from one another, even in a net metering scenario, as they may be able to pair other technologies with a net metering-like service, or they will potentially be able to offer different rates, which will have an impact on the value of the credit and will then result in giving the customer an opportunity to make a decision as between, similarly situated providers who are both offering them a net metering option. So this is a sort of a long way of saying I don't think that the language of the petition itself undermines in any way the existing construct. There is some work to be done to conform it, but I would say also, to Mr. Sullivan's point, that what is clear is that the legislature, in attempting to accommodate the net metering program in a competitive environment, has already indicated that as a matter of policy, they want that to go forward. And so, unlike some of the other issues that the Commission may consider in the course of this proceeding, at least I think we know that from the policymaker's perspective, as we sit here today, there is no question as to whether net metering should continue in more or less the same fashion as it exists. Now, the question is only sort of as a matter of mechanics, how to get there.
No, first of all, thank you. Thank you for coming up. And what I'm looking at, in the reason that I'm asking these questions, again, is to make sure that there's not unintended consequences that we aren't foreseeing now. Because if we look at 30,000 plus net metering customers, I don't want to go backwards, and I don't think anybody wants to go backwards in any way whatsoever. And if NV Energy is pulling out, that they're no longer saying we are servicing those customers, we are no longer going to be a part of that financial arrangement, who's going to step in? And that's my concern. And who would want to step in if they were forced to offer a energy price that was mandated by law as opposed to market forces? And will there be anyone to come in to fill that void to make sure that those customers' expectations as they exist today will still be there in reality, 10 years from now?
And I think that's entirely fair. I also think that to the extent, let's say there's a scenario where no one wants to deal with a net metering code. I don't think that's reality, but if that were the case, and I think this goes to some of the other questions that may be raised as to certain renewable policies that exist today and how to perform them. But at least in my view, I don't think that there's anything in the language of the petition itself that precludes policymakers from ensuring the continuation of those policies as legal requirements to entering or participating in the market, number one. And I also think that your questions kind of raise the issue of what will a provider of last resort or providers of standard service offers have to do to close the gap between what competitive retail provider may be willing to do and what the state says as a matter of policy we have to have.
So is one option, at least in dealing with this concern, is requiring someone who's entering into the market to service a certain percentage of those net metering customers on the current terms of 405.
I think that that's an idea that is on the table in terms of filling a true vacuum. Again, I don't know that seems to me a realistic possibility. I think that there are many providers who have an incentive to offer net metering service on the terms that we have under the law today. But I don't think there's anything in the law or that will exist in the law that will preclude generally applicable sort of market entry requirements like that.
Okay, no, thank you, Mr. Fletta. Again, because my concern is, right now we are using the force of law to mandate NV Energy do what it's doing. They have to accept excess generation, whether they want to or not. They have to do it. And if other businesses come in and say we don't want generation from rooftop solar because we have some from California that we have that's even cheaper. How do we reconcile that?
Are you sorry? Is that?
That was a slight comment, slight question.
Well, I think I sort of addressed it already. So.
Thank you, Ms. Terwilliger. Thank you for coming up.
Thank you, Chairman. Debra Terwilliger for the record. I think I'm going to largely agree with you and Mr. Fletta. The initiative, and we didn't hear the drafters speak to this today, but I think if you look at 3C where, and Mr. Fletta pointed this out, this isn't meant to invalidate any of the policies, renewable energy policies of Nevada. But having said that, I think that you're right. The statutes are all these statutes are going to have to be looked at in the construct of this initiative, and we're going to have to revisit these issues. I certainly don't think there's anything in this initiative that would invalidate the premise of AB 405, but at least my understanding, and since I'm new again to the state, is that AB 405 is the net metering is premised on the definition of a definition of a utility. So that statute will have to be revisited if we're going to apply it to retail service providers or alternative sellers or whatever we want to call it. So I agree with Mr. Fletta that I think the initiative by saying nothing is construed to invalidate Nevada's policies towards renewable energy means that statutes might have to change, but our policies, need to be looked at so they can continue under the initiative language. But it is something that will have to be revisited, I think, in terms of how we apply this to retail service providers or alternative sellers.
Thank you. I just, want to make sure that we don't have a party, so to speak, and nobody shows up. One of the other questions that I also had regarding looking at law changes, we have several laws in Nevada that sometimes here at the commission we refer to public policy laws or public policy costs that are intended to help either renewable energy programs, energy efficiency programs, low-cost or low-income Nevadans pay their electric bills. Universal Electric charge for one, the energy efficiency charge for another. In those, some of those are in our actual NRS statutes. Will those have to be changed? Will those be impacted by this new ballot provision? Because right now, as public policy objectives is determined by our legislature, whether someone who wants to call them a fee or a tax or a charge, I hear everybody spin them the way that serves their purpose sometimes, but they are costs that are added on to all Nevadans' monthly bills to service public policy objectives that the legislature thinks are important. Is there any thoughts on whether this petition will impact the ability of the legislature to impose those on bills? Because again, they're not necessarily true costs of the energy, but they're things as a society we want to put on our energy bills. In the legislature has determined that's appropriate. Will those go away? Will those stay in place? Mr. Sullivan?
Chairman, for the record, Dylan Sullivan again from the Natural Resources Defense Council. In our initial comments, we spent a lot of time on energy efficiency policies, and I think a lot of what we said could be extended to Nevada's new electric vehicle policies as well. So I think to directly answer your question, I'm again going to lean on section 3C of the initiative that doesn't change Nevada's existing sort of policy decisions, or it's not intended to change the ability of the legislature to basically effectuate energy policy in this new market structure. So I don't think the initiative precludes the legislature from doing energy efficiency programs or electric vehicle programs. But I think what you're hitting on is that if the initiative were to pass again and energy choice becomes something that the state has to implement, and I just want to reiterate again NRDC's neutrality on the initiative. If that does happen, I think that the state and that lawmakers are probably going to need to change the sort of legal base of those policies. So right now, for example, energy efficiency exists as part of the resource planning statute. And of course, we don't know what's going to happen to resource planning in this new market environment if it comes to pass. So what we argue, and I think what we show, is that in states that have gone through this transition, they have generally kept their public policies or kind of doubled down on them related to energy efficiency and said that, regardless of this new market structure, the same reasons that we were doing energy efficiency in the past, those same policy justifications remain in place. And we need to figure out how to do energy efficiency in this new environment. And basically what states have figured out is that they can either have the distribution utility run energy efficiency programs, have them be tasked with running programs. Maybe they have to save a certain percent of electricity each year. And they collect those costs from all customers on a non-bypassable basis and maybe do something special for large customers who are sophisticated energy users. That's one option. The second option is kind of the same cost collection mechanism, but have a third-party provider run energy efficiency programs. So I think those are both options.
Thank you for those thoughts. Mr. Weber.
This is Josh Weber for the record. I agree with the NRDC's position regarding energy efficiency and the state's ability to continue to set policy, and I believe that is one of the points that's very explicitly stated in the face of the initiative in 3C. One point I might add is that should a distribution company or a distribution utility or a trust or third party of some kind be involved or be the party that is carrying the water in the energy efficiency arena, there is actually a potential that there will be less conflict in terms of aligning interests, because the throughput incentive, which might have previously made folks feel, less excited about decreasing the load that they're collecting their volumetric charges through decreasing the load which they rely on for their volumetric rates to recover the revenue requirement. Well, that may go away. The throughput incentive, says that you have a disincentive to vigorously prosecute energy efficiency if you know you're going to be taking away kilowatt hours from your sale. But that wouldn't be the case if a distribution utility were implementing the program, because the distribution utility doesn't care how much goes over the wires. Their job is to run the wires, not produce the energy. Likewise, there has been mixed results with energy trusts, but certainly they're an option that the state needs to look at. Some of them perform quite well, and some of them do less well. But that's kind of a long ways to say there are good solutions to this issue, I think, and plenty of space in the law. I will note that another program that you mentioned, low-income assistance, isn't mentioned specifically in 3C. But Mr. Griffin earlier pointed out that 3C was something he added just to be extra super clear about the question of renewable and energy efficiency policies. And absent 3C is the belief of those who drafted the Energy Choice Initiative that these other public policies are not affected anyways. Low-income, others that are not specifically listed here may not have the double protection of being affirmatively protected in 3C, but we do not believe that Energy Choice Initiative would affect the state's ability to do them. Might affect who collects the money.
Who would collect the money? Or do you have any ideas on who would collect the money?
Again, we would want to look at what has been the best solution in other states to make it really, really work. But the obvious answers, I think, are the distribution utility, who is still going to be connected, or put that task upon the energy service providers as part of what they're required to offer. As Mr. Folletta stated earlier, there's a requirement of general application imposed that we do not believe in any way conflicts with this language.
Thank you, Mr. Weber. I guess one thought in my mind is that from at least some of the comments and the feedback that I'm hearing is if this petition passes, that the government will still have the ability to impose taxes, all kinds of energy efficiency, universal service charge fees, to mandate what type of electricity is used in the sense of a renewable portfolio standards, still make sure that consumer protections are in place to ensure reliability, vetting of companies that enter into the market, to mandate that those companies provide for rooftop solar customers. Isn't that a lot of what we're doing right now? I mean, that's the system we have in place, except for it's that NV Energy collectively, as Sierra Pacific Power and Nevada Power Company are the entities that are presided over in doing that.
Yeah, Josh Weber for the record. Mr. Chairman, we agree with you on that. We're already do those things, are already important functions, and this initiative was not meant to liberate or liberate folks from those requirements or taxes or however. It is not meant to take a position on those public policies, rather to simply set up a different vehicle through which the state can implement its policy.
And is it again, while we're just having the conversation, one thing that the Public Utilities Commission does is it takes all those different variables, and every 3 years in a general rate case, sets a rate, or at least a range of a rate that the company has to abide under. And one of the reasons that has happened or evolved that way is in an attempt to protect consumers, protect customers from rate shock, from volatility, from anyone trying to manipulate the market, so to speak, and to make sure that there's some continuity. And we're removing at least that component of the rate-making function with respect to the generation. Is that correct?
Josh Weber for the record. I don't think we are. We may, the legislature may need to talk about how that's going to be done. But those other charges, whether they are, mill tax or whether it's funding for low income customers, those aren't the energy rate. Those are non-bypassable charges that are tacked onto the energy rate. So the market can be setting the energy rate, and then whether it's through the energy providers or whether it's through the distribution utility, the commission still has, I think, the opportunity and the obligation to offer those consumer protections by adding, telling folks, here's the charge. You're selling energy, you've got your prices down as low as you can, well, here's the charge that you add on for low income. Or again, perhaps it goes through the distribution utility. I really don't have a strong feeling about that. So I believe it's vital to keep those protections. The role of this commission, as Mr. Griffin pointed out earlier, doesn't go away. It's re-regulation, not Wild West.
No, and again, thank you for that. And again, I'd ask nobody to infer by me asking questions. I just want to have that dialogue out there on the record, so that the conversation is out there, because that is something that is been on my mind. Because one thing I wonder is, when we're discussing, what statutory provisions, what provisions of the Nevada Administrative Code might need to be amended. Some of the ones that come to my mind, we look at NRS 7, Chapter 701, 703, 704, are some of the real key ones, especially 703 and 704. And is it possible to accomplish the intent of this petition by changing just a few key words in some key places, or is that might be naive on my part, or is this looking at a wholesale rewriting of all of those provisions? I guess is there an easy way to do this, or is it just going to be a hard way, and that's just the way it is? Do you have any thoughts, Mr. Weber?
Yeah, Josh Weber for the record. In the end, it may be that it's easier simply to do a wholesale start from scratch, new cloth. However, certainly there are pressure points, where tweaking the language that exists could do much of the work. I think that it will take the legislature sitting down and probably with legislative council and saying, can we get to where we want to go by changing this provision, by removing this one? Some things have to come out. There was a pretty good list presented earlier. I think we need to be open to both options, and I'm not sure which one would be easier at this point.
Well, thank you for the candor in that answer. I mean, again, you wonder, do we light the fire and put those NRS provisions and just rewrite again, or I imagine what a workup might look like with amended language and crossed out language. It might be pretty cumbersome as well, and is it easier just to start again or not? And that, again, I think that's a conversation to have, and a conversation to have now, as opposed to in the middle of a legislative session when there's a million things going on. And so thank you for that.
We'll give it some thought before we get to the second round on this issue.
Thank you, Mr. Weber. Mr. Volz, go ahead.
Yes, for the record, Fred Volz again. Mandates do have cost consequences. Each time one is layered upon another, there's going to be an impact to the cost structure. And we're going to have this conversation in more detail Friday. But in the interim, it seems irrefutable that the Energy Assistance Program, as it currently constituted, doesn't begin to cover the needs of low-income residents of this state. It doesn't cover close to 100% of their energy bills. And if indeed, by inserting more layers and more cost factors like a call center, a new RTO or ISO, even increased PUC staffing into the mix, we're going to have to somehow change legislation to up the funding for that energy assistance program, unless, as a public policy issue, we're unconcerned with more people falling off the system and not able to afford their utility bills, especially in the South where the air conditioning is such a critical factor and time of use is not an option for those people. Thank you.
Thank you, Mr. Volz. Mr. Williger.
Chairman, thank you. Debria Twiller for the record. I just heard your question to Mr. Weber and I wanted to weigh in. I know staff didn't initially file comments sort of identifying the statutes that need to be changed, repealed, added to. But we've started that process after reviewing the comments, and you'll see some comments from us during the comment period. My only thought is I'm not sure there's a trigger point where we can make simple changes. I think it's going to be, it might take all 3 sessions and a wholesale rewriting of the NRS to implement this initiative from our perspective. After kind of giving some thought to what the comments said, how things are going to change, I think will be a wholesale, there'll be a lot of rewrite of the statutes. So.
Thank you, Mr. Williger, because I think of many of my friends that work at LCP right now, and the workload that they have during a legislative session, and they're working every day, every night, just in a normal session, and the amount of work that's involved with doing something that's so important to get right, with everything else going on in the session, to make sure that there is the support there, the vision there, kind of some of the groundwork there out of the gate to move that process along, or else hire them a lot more lawyers. If you give me just one moment to look at my notes here. My understanding is that when Nevada looked at restructuring the energy market back in the late 1990s, when there was an attempt to impose a rate cap, it did result in litigation in federal court. Are there any similar concerns that if there was a rate cap even during a transitionary period through this petition, that it also might result in litigation? Or is that too hot of a topic for anyone to want to touch right now? For the record, no one's stepping forward. Probably on advice of counsel. Mr. Volz, go ahead.
I'll opine on that issue, Chair. Costs don't just disappear. You can not wave your magic wand and have them go away. And if the costs aren't recaptured immediately, they're pushed off to some other person, or they are eaten by the shareholders of the company that's providing the service, assuming it's a publicly owned company with shareholders. So to try and alter that, short-term or long-term, is really a zero-sum game. You're not going to get anywhere with that, because at some point, somebody is going to have to pay those costs. Thank you.
Thank you, Mr. Volz, and I absolutely agree with what you said. They have to go somewhere, and somebody has to pay at the end of the day. I'm going to take a brief 15-minute break to give our court reporter a break. We've been going for about an hour and a half, and we'll resume at 3 o'clock, and then wrap up for the day. Thank you.
transitioning from a company of retail, whatever it has to be, but they have to have everything, something really happens, they have to have that communication. So it's very unique. Well, 99. They were larger than the one in the south. They had too much turnover rates. Sierra kind of acquired that power. People out here that were just applying the power. And Sierra had been fortunate because they had a ratio. It was AES. So make new W. Yeah, and then he's gonna come back. I heard that. Yeah, whatever. I heard the important.
Hi, Josh, Angel. At PUC, do you have your Wi-Fi hooked up here? Yeah, I keep trying it, and it's showing that it's very, very, very weak, and that it'll connect for maybe 10 seconds, and then it just goes over into my save. It'll not, because I've got a Cox Wi-Fi that's connected, and now it's flipping over, believe it or not, to Tiara. It can't make its mind up. Oh, okay. I didn't know. What are they doing on the second floor? I saw them taking out massive pieces of metal. Oh. Oh, okay. Okay, maybe I'll just move around and see if there's a stronger connection somewhere. Okay, thank you, Josh. Take care.
I guess the
that's possible. Yeah, I know Libby really well, and obviously Shelley, she's great, so.
Tomorrow, if you could go for the full day.
Okay, oh, great. I know, well, and they're both up there, so obviously they've got some folks down here.
This isn't their world.
No, it's, luckily it's not many people's world.
Hi, I just wanted to introduce myself. I'm John.
Hi, we've met before, Chelsea Cooper, I work with Josh and John.
Excellent presentation. So like one of the subcommittees or work groups
Yeah.
about our contract and stuff. It was really well done.
Walk around a
I
little
was
bit.
participated in that one side years ago because I worked for Alliance when they built the Eldorado plant.
I do, yeah, I actually,
It's
grew
simple
up down
stuff
here,
now.
lived up
But,
north, and
I had no idea
college
the
for a lot of
complexity
years,
of
and
what she
actually
had
moved
stuff
back
until
to
you did the presentation. I mean, I kind of knew a little bit about private use restrictions and all these kind of things, but nothing what you guys got into. So it was really cool. I just wanted to introduce myself. I'm John Orr with Exelon. Hi, nice to meet you. Oh, okay, cool. Yeah, so we're the biggest commercial industrial retailer under the Constellation brand, is what you would see. But Exelon's the parent.
We're back on the record here in Carson City in docket number 17-10001. My name is Joe Reynolds. I'm presiding over this matter with respect to the PUCN investigation and workshop into the Energy Choice Initiative. A few final questions that I had for the workshop today, and that I would ask for anyone who's interested in following up on some of these questions for next week. Some of these questions are as follows, and I would appreciate any further information or insight into the impact of the Dormant Commerce Clause that might come into play with respect to this constitutional amendment. Again, with respect, if the legislature determines as a matter of state policy that we do not want nuclear energy to be used or consumed in this state, and that's something for the legislature to decide. Is there a compelling state interest to prevent that in light of this constitutional amendment? Just because Nevada doesn't like it doesn't necessarily mean there's a compelling state interest. And by enacting this constitutional amendment, does that limit the state in any way? Another question that would be helpful for me is with respect to the net energy metering issue. And we heard some discussion and some answers today, which I very much appreciate, regarding who will come in and fill the void, so to speak, if NV Energy is no longer in a relationship with respect to generation in AB 405 customers. And right now, with respect to the excess energy credit, it's a bundled rate where you have the transmission, the distribution, and the generation component in the credit that's given back to the NEM customer. And if we change that paradigm so that you have a new choice with just the generation component, but still the transmission and distribution costs are out there, again, how do we make sure that the AB 405 customers, that the rates that they're expecting right now will remain intact? And another question that I have in my mind with respect to this petition is it does seem to create a right to generate. And when we say right in America, we mean it's a right, and we love our rights in America. But the litigation background of mine in representing the state in litigation is that when you have a constitutional right, you also have Section 1983 claims of where you're saying there's a state deprivation of a constitutional right. And by this amendment, we are enshrining a new constitutional rights that aren't recognized and haven't been recognized as a constitutional right by other states? And does that raise new claims in litigation? That if for example, Washoe County enacts an ordinance to limit my ability to have a windmill on my property. Well, now I have a constitutional right to generate my own power. Is that ordinance now therefore unconstitutional? Because I have a new constitutional right, and if I was someone who wanted to build a 300-foot windmill in my backyard, I might make that argument. Those are some things, and then you can go the other side of that and say, well, even with constitutional rights, there's reasonable time, place, and manner restrictions that can be put in place to temper some of those rights too, so that they're not all expansive. But those are some questions that I have in looking at this. And when we retake up the legal aspects of this law in the workshop next Tuesday, any attempts to find some answers to those would be greatly appreciated, as well as any of the other questions that have come up through today's proceedings would be very much appreciated. Whether it's follow-up to expand upon previous answers by any of the commenters, that's something that I welcome. Again, this is a dialogue, a conversation I'm looking to have because we're just looking for answers. And so I want to thank everyone today who showed up, both here in Carson City and in Las Vegas, and also everyone who spoke today on the record. Very much appreciate it. And with that, I'm going to conclude today's portion of the workshop. And I hope, my concern is as these workshops go on, the room will get smaller and smaller and smaller. But I hope it doesn't, because again, what we're looking at doing here in the state is extraordinarily important, and I think the more eyes on this, the better, to make sure that we get it right. And so again, thank you, and we will resume day 2 of the workshop tomorrow at 10 o'clock and begin discussion of the establishment of a wholesale electric service market, including but not limited to reliance on existing bilateral markets, establishment of contractual relationships, and possible governance structures. And I hope our friends from CAISO are here and ready to participate robustly. And so again, thank you everyone, and I'll see you tomorrow.